Let's talk about Section I, mandatory seller disclosures in real estate transactions. I1 is seller's obligation to disclose. Part A says disclosure of material facts pursuant to Hawaii Revised Statute, which is HRS Chapter 508D, for the sale of residential real estate property, which means fee simple or leasehold real property on which currently is situated. One, from 1 to 4 dwelling units, which is basically residential. Anything above 4 unit becomes commercial. Or 2, a residential condominium or co-op, the primary use of which is occupied as a residence, and under common law, seller is obligated to fully and accurately disclose in writing to buyer any fact, defect, or condition, past or present, that would be expected to measurably affect the value of the property to a reasonable person, a material fact. Seller acknowledges and agrees that the disclosure requirements under Chapter 508D are in addition to all other disclosure obligations of seller required by law relating to the sale of real property. So basically, in a nutshell, what this is saying is any seller of residential real estate is obligated by law to complete an SRPDS, which is a seller real property disclosure. And so this is what this is pertaining to. I1B is mandatory provision of disclosure statement. Unless exempt in Hawaii Revised Statute, Chapter 508D, no later than X amount of days, seller shall provide buyer with a disclosure statement, a written statement prepared by seller at seller's direction, signed and dated by seller within 6 months before or 10 days after the acceptance date. So here's in a nutshell, this particular section of the purchase contract is super, super important because it provides and gives a lot of opportunity for the seller to disclose everything they might know about the property. This is not a warranty or a guarantee, meaning that they're warranting the condition of the property, but it is absolutely everything that they might know of. And one of the largest reasons for a lawsuit after conveyance or closing is non-disclosure. So know that's a big deal, which is why it's so important that the seller disclose. So in this particular case, if we're originating a purchase contract, we're receiving that seller disclosure. A lot of agents I see when they write this, they'll put in there an I1B, they'll put, for instance, 10 days or even longer. I do not recommend that. You want to get this seller disclosure as absolutely quickly as possible. And the thought process is, if you get it, you should be reviewing it, asking questions. Maybe if they put on the seller disclosure, we had AC repaired, 3 times in the last 3 years, as an example. Maybe you might ask who that repair person is. Are they licensed? Is there a warranty? Is there a guarantee? If they had a new roof put on, by whom? Are they licensed? Is there a warranty that is transferable? Do I have to pay something? All those things are things that, if it's not detailed in the SRPDS, you as the buyer's agent should be asking that question. So therefore, in I1B, the days should be as low as possible. It should literally be no more than 3 days. I would even recommend 2 days. And so timeline wise is you enter into escrow, within 2 days you get the seller disclosure, and probably within a day after that or so, that's when you have the home inspection. If you reviewed the seller disclosure, you've made notes, you've asked questions, you've kind of picked it apart a little bit, you've then disclosed it and provided it to the buyer for review. You then want to take that seller disclosure and hand it over to the home inspector so that they can look through a different lens and be more forensic about how they look at the property in whole when they're doing their inspection. So, for instance, if the seller says, there's a leaky roof that we had repaired 3 years ago, and you see a little bit of a stain or residue, that's helpful to know, to provide that information over to the home inspector so they can pay closer attention to the areas that have in the past posed an issue. So bear that in mind. That's I1B is super, super important. Don't use long days. Use a short time frame as much as possible. Buyer acknowledges that the disclosure statement is not a warranty of any kind, as I just mentioned. Pursuant to Chapter 508D, the disclosure statement shall not be construed as a substitute for any expert inspection, professional advice, or warranty that buyer may wish to obtain. Equally important is I2, amended disclosure statement. Pursuant to Chapter 508D, seller is obligated to provide an amended disclosure statement upon later discovered information. if after seller delivers a disclosure statement, so this is after they've already given you the SRPDS to the buyer, and prior to closing, seller becomes aware of information that was not previously disclosed or that makes any statement in the disclosure statement inaccurate, and said information directly, substantially, and adversely affects the value of the property, then seller shall provide an amended disclosure statement to buyer within X amount of days after the seller's discovery of the non-disclosure or inaccuracy, and in any event by no later than 12 noon of the business day, the last business day prior to the recording sale of the property. So this is the amended disclosure. And I often will see here as well, people put 7 days, 10 days, even longer for that matter. Let's say that you're in the middle of an escrow. You've already had the seller disclosure, and you've already had the home inspection, and the seller then informs you, hey, and you're maybe like 2 days away from closing. So you've already signed loan paperwork for the buyer. They're getting ready to close. And the seller advises you 2 days again before closing. They tell you, hey, just let you know, the central AC unit is not working, but don't worry, we're going to send someone over there to take a look at it. But they don't disclose it. The purpose of the disclosure is to kind of, depending on the how substantial that issue is, that repair, that need for service or remedy, it allows you some more time that you can review this information. If they knew this, let's say 7 days prior, but they're only telling you that now, it's because that's what that contract states. That those number of days that are in there are super important. I'd recommend that you have like no more than 1 or 2 days in I-2. And that means if the seller becomes aware of something that's inaccurate or additional information that they didn't disclose previously, they have to, within 1 or 2 days, tell you that. And again, that's super important, especially if it says 7 or 10 days and you're 2 days away from closing. That's a problem. Like it's almost hard to pump the brakes on that transaction from closing. And if it's a substantial situation, maybe AC or roof or foundation or water leak or something like that, that could be detrimental after closing to the buyer. Moving on to I-3, buyer's rights and obligations upon receipt of disclosure statement or amended disclosure statement. A is upon receipt of disclosure statement or amended disclosure statement provided pursuant to paragraphs I-1 or I-2, buyer shall provide seller with a written acknowledgement of each within X amount of days of receipt. This number can be low. This is just acknowledging receipt that they've gotten and had their hands on these documents, either for the I-1A or I-1B or I-2. This could be 2 days, not a big deal. Upon receipt of disclosure statement provided pursuant to paragraph I-1, buyer shall have blank days to examine the disclosure statement and to rescind the purchase contract. This, you want to have a longer timeline. This gives you the opportunity to either renegotiate or to send, depending on the extent of that circumstance. Maybe they've indicated something very unusual about a sewer line, or maybe it's a PV system that's not working well. It's something along the lines of your home inspector, your general home inspector can't diagnose, and you need a specialist to come in and take a look at it. The reason why you want this as long as possible is you want to give that opportunity so that you can say, hey, do you mind if I send a specialist in there to take a look at it? So you want a longer period of time as much as possible, especially because it puts the negotiation back into the buyer's hands. C goes on, upon receipt of an amended disclosure statement, buyer shall have blank days to examine the amended disclosure statement and to rescind the purchase contract. So the first one is talking about the initial disclosure. The second C is talking about the amended disclosure. Same exact thing. You want this as long as possible, because finding new information that may have arisen after the disclosure still might require a specialist to go in and take a look at it. It might be a moment of pause to get some estimates or what have you. So you want to have as much time on there as possible. D, should buyer elect to rescind the purchase contract pursuant to subparagraphs B or C, buyer must give seller or seller's agent written notice of such rescission within the specified time frame, and the termination provisions in paragraph O2 shall apply. O2 allows for the buyer to receive their earnest money back in return. I-4, buyer's rights and obligations upon later discovered inaccurate information. Upon discovery by buyer that the disclosure statement or amended disclosure statement fails to disclose a material fact or contains an inaccurate assertion that directly, substantially, and adversely affects the value of the property, And if buyer was not aware of the foregoing failure or inaccuracy, buyer may elect to rescind this purchase contract within the earlier to occur of A, 15 days of the discovery of by the buyer of the failure or inaccuracy, or B, blank amount of days of the receipt of an amended disclosure statement correcting the failure or inaccuracy. Know that right here, buyer may elect to rescind this purchase contract within the earlier of the two. So it's either going to be 15 days or whatever this number is. So if you put 7 days, it's going to be 7 days. It's the earlier of the two. So make sure that you know that. If you're on the sell side of this, one way to shorten that fuse, because, as real estate agents, we give contrary advice depending on who we're representing, the buyer or seller. So I would tell you that if you're on the buy side, you want this as long as possible because you want as long a time frame on that. But when you're on the sell side, you want to shut as many windows as possible. And one thing that I have done in the past is if you attend the home inspection, you're on the sell side, you attend the home inspection, you can see and hear what the home inspector is advising to the buyer. You can take note of that and ask the seller if they want to update the seller disclosure and then redisclose it, basically I-2, right? You're amending the seller disclosure to include additional items that they didn't know about. And oftentimes, in my experience, 100% of the time, a seller disclosure is not going to provide all the information. Generally speaking, a home inspection is going to be far more detailed because it's not as though the seller knows that outlet that's behind the sofa that's been there for 10 years straight doesn't work. How would they know that? Or they weren't in a crawl space in underneath the home or in the corners of the attic or whatever it is. They don't go into those areas, whereas a home inspector does. So oftentimes a home inspection report is going to have far more details as far as any deficiencies or things that need repair or remedy than what the seller disclosure would provide. So the listing agent attending that home inspection debrief and then having the seller update that could be beneficial. So that's on the list side, but on the buy side, you want to have this as long as possible. I-5, buyer's remedies regarding mandatory seller disclosure statement. If seller fails to comply with paragraphs I-1 or I-2, buyer may elect to complete the purchase of the property, so they can still move forward if they wanted to. When buyer is provided a disclosure statement, documents, or amended disclosure statement, and buyer decides to rescind this purchase contract, buyer shall not be entitled to any damages, but shall be entitled to the return of all deposits. And in such case, buyer's deposits shall be returned immediately. If seller negligently fails to provide the required disclosure statement, documents, or amended disclosure statement, seller shall be liable to buyer for the amount of actual damages suffered as a result of seller's negligence. A court may also award prevailing parties attorney's fees, court costs, administrative fees. Buyer's rights to rescind this purchase contract under paragraphs I-3 and I-4 shall not apply after the scheduled closing date, because obviously you've already closed. Any action to rescind the purchase contract under paragraphs I-3 and I-4 shall commence prior to the scheduled closing date. I-6, general disclosures. Paragraph I-6A through I-6I describe general issues which could affect the property. Buyer should make appropriate inquiry regarding these issues as part of the buyer's inspections rights under J1. And it goes on, and I'm not going to read every single detail, but A, governmental and private restrictions disclosure, B, building permit disclosure. By the way, when you write your purchase offer, in certain circumstances, you can ask for a premium building package or a permit package to see what is permitted or not. C, asbestos disclosure. Obviously, we have the lead-based paint disclosure that's already built into that if property is built 1978 or earlier. Hazardous waste and toxic substance disclosure, wastewater disposal disclosure, mold disclosure, sex offender registration, flood zone, lead-based paint renovation, repair, painting, climate change, wired funds, and that satisfies and that completes section I.